Welcome back to Advocacy Alchemy with Professor Ross. We're going to jump back in with the Sean Combs situation. We have another document that we had yesterday that we paused on. So we went through the indictment, talked about the ins and outs of that. Today, let's talk about the detention memo that was submitted by the United States Attorney for the Southern District of New York, asking for the judge to not give a bond to Sean Combs. All right. So with that, let's jump into our main document here. All right. As you see, we have the document here. Let's take a look at the different portions of it here. Here's the case number up here. 1:24 CR 542 ALC. We can tell it was filed yesterday, 9/17/2024, and it's page 1 of 16. Here's the judge of this case, the magistrate judge. So in federal court, you have magistrate judges, you have district judges, you have circuit judges that are on the appellate level, and then you have the Supreme Court justices. Magistrates, they serve, 8-year terms. District judges and up all serve for life. Okay? So this went to Judge Robin Taranovsky. We see the name of the case, United States versus Sean Combs, and all his aliases. And we get that same case number again, 24 CR 542. All right, let's go through this memo that was sent to the judge's office for the judge to review regarding. This is basically the bond recommendation that was submitted by the state's attorney, by the United States attorney, to the judge before the judge makes a decision on bond. All right, let's read what it says. It says, "Dear Judge Taranovsky, the defendant, Sean Combs, was taken into custody this morning after a grand jury sitting in this district returned a 3-count indictment charging him with crimes related to his decades-long pattern of physical and sexual violence against multiple victims, and his use of force, threats, and coercion to enact his will, protect his reputation, and fulfill his sexual desires. The government respectfully submits this letter in anticipation of the defendant's appearance before this court later today, and in support of the government's request for the defendant's detention pending trial." Let's pause for a second. And that's a perfect place for us to, let's put the screen out. Oh, I didn't mean to do that move, but all right. Let's put the screen out and let's take a look at this. All right, in federal court, reasons to not be granted bond. 18 U.S.C. Section 3142. Release or detention of a defendant pending trial. In federal court, a defendant may be denied bond or pretrial release if the judge determines that no condition or combination of conditions will reasonably assure the defendant's appearance at future court proceedings, or the safety of any other person and the community. Key factors influencing this decision include nature and circumstances of the offense, charges involving serious crimes such as violent offenses and major drug trafficking may lead to a presumption against release. Weight of the evidence. Strong evidence against the defendant can be a compelling reason to deny bond. Defendant's criminal history. A significant criminal record, especially with prior failures to appear or violent crimes, can influence the court's decision. Ties to the community. All right, lack of stable employment, family support, or a permanent residence may increase the perceived risk of flight, meaning that somebody will run. All right, risk of flight. If the defendant is deemed likely to flee the jurisdiction to avoid prosecution, bond may be denied. Lastly, danger to the community. Concerns that the defendant may commit additional crimes, may pose a threat to public safety, can result in denial of pretrial release. Okay? All right, we'll leave that for a second. Let's jump back in. As set forth below, there is no condition or combination of conditions that will reasonably assure the appearance of the defendant as required and the safety of others and the community, not to mention the integrity of the proceedings. As reflected by the gravity of the charge, or the charges in the indictment, the defendant is dangerous and poses an ongoing threat to the safety of the community. If released, he remains a serious risk of flight, despite the conditions offered by his counsel. Most glaringly, the defendant also poses a significant risk of obstructing justice. Okay? Indeed, and as set forth below, during the course of the charged conduct, the defendant has attempted to bribe security staff and threatened and interfered with witnesses to his repeatedly contacting victims and witnesses and feeding them false narratives of events as described in detail below. There are simply no conditions that would ensure the defendant's efforts to obstruct and tamper with witnesses will stop. The defendant therefore cannot overcome the statutory presumption in favor of detention, and the court should order him detained. They give us the statute there. Let's see if that's the same statute that we pulled up at the very beginning. Exact same statute. Did not want that to split out like that. All right, background. On September 17th, 2024, an indictment returned by a federal grand jury sitting in the Southern District of New York. The indictment was unsealed, charging the defendant with racketeering conspiracy from in or about 2008 through on or about the date of the indictment. In violation of USC Section 1962D, Count 1, sex trafficking, from in or about through 2009 through in or about 2018, in violation of 18 USC Section 1591, 1 and 2, Count 2, and interstate transportation to engage in prostitution from in or about 2009 through in or about 2024, in violation of 18 USC Section 2421, A1 and A2. They call that count 3. So what he's doing here is he's just basically giving the judge an overview of the indictment that came back, and he's going to have some of the other information that was not expressed in the indictment for reasons that they believe that Sean Combs should not be granted bail. Now, his lawyers had offered up, I believe, about $5 million in assets. And they're going to talk about that here. Let's jump back in. A, Combs' use of violence, threats, and coercion. Since at least 2008, the defendant and other members and associates of the racketeering enterprise alleged in the indictment, known after this point as the enterprise, which includes the defendant's multifaceted business empire, the Combs business as it will be known from this point forward, wielded the power and prestige of the defendant's reputation as a musician, entrepreneur, and figure in the entertainment industry to commit federal crimes, including racketeering, sex trafficking, and other offenses. As charged in the indictment, many of those crimes involved the sexual abuse and exploitation of women and other crimes of violence. All right, so they want to paint the defendant a certain way, and now they're going to tell Judge Moore about each of these that they're alleging. All right, number 1, sex trafficking and abuse. It says here below, using the power and prestige of the enterprise, the defendant lured female victims into the defendant's orbit, often under the pretense of a romantic relationship. The defendant then used force, threats of force, and coercions to cause female victims to engage in sexual activity, force them to have sex, which included frequent sex acts with male commercial sex workers that the defendant referred to as freak-offs. Freak-offs were elaborate sex performances that the defendant arranged, directed, all right, pleasured himself to, masturbated to, during, and often electronically recorded. Freak-offs occurred regularly from at least in or around 2009 through this year, sometimes lasting or sometimes lasted multiple days, and frequently involved multiple sex workers. The defendant arranged freak-offs with the assistance of members and associates of the enterprise, including employees in his business, and the hotel rooms where they were staged often sustained significant damages. What? They have a heading here or a footnote to go down here to the bottom. So we look for the number 1 below. It says, for example, in approximately 2012 in Manhattan, the defendant paid over $46,000 to cover damages to a penthouse hotel room following a freak-off. It's quite a bit of damage to a hotel room. 46,000. That's crazy. All right, the next paragraph reads, the defendant ensured the victims would participate in freak-offs through coercion and violence. For instance, the defendant provided controlled substances, including ketamine, ecstasy, and gamma hydroxyl butyrate, GHB, to female victims so that they could and would continue to engage in freak-offs despite fatigue, physical and emotional exhaustion, and pain. Additionally, both during freak-offs and separate from freak-offs, the defendant subjected female victims to physical, emotional, and verbal abuse, in part to cause them to engage in freak-offs. The defendant hit, kicked, threw objects at, and dragged female victims, sometimes by their hair. At least a dozen witnesses will confirm that they personally observed the defendant's violence towards women and or the injury sustained by women at the defendant's hand. One incident of physical abuse occurred when a female victim was attempting to leave the hotel following a March 2016 freak-off. This abuse was captured on video surveillance and publicly reported in May of 2024. It has a number 2 heading. It says an excerpt of this video footage is attached hereto as Exhibit A. That's a Cassie video, I believe. The defendant assaults others. The defendant's assaults often resulted in serious injuries to the victims that took days or weeks to heal. The defendant also coerced victims into participating in freak-offs by controlling their careers, finances, livelihood, and or housing, among other aspects of their lives, or by threatening to disseminate recordings of the freak-offs. The defendant used his considerable wealth and influence to make victims rely on him financially. For example, by paying for their rent or their cars or by offering them career opportunities. Once he provided his support, the defendant repeatedly threatened to take it away to ensure the victim's compliance with his demands, including their participation in freak-offs. Indeed, victims believed that they could not refuse the defendant's demands that they engage in freak-offs without risking their financial security or career prospects, or without repercussions in the form of physical or emotional abuse. So that basically says that the people in his orbit that were subjected to abuse felt that they couldn't do anything otherwise, or they'd be bankrupt, or their careers would be bankrupt. And they basically just felt forced to do whatever Sean Combs wanted them to. All right. Let's move into number 2. Other violence. This says, in addition to the defendant's physical, sexual, and emotional abuse of his romantic partners, the defendant repeatedly engaged in acts of violence directed toward his employees and others. As charged in the indictment, the defendant often assisted by members and associates of the enterprise, engaged in kidnapping, arson, and physical violence, such as throwing objects at people, throwing people to the ground, and hitting, dragging, choking, and shoving others. Numerous witnesses, including the defendant's employees and others, observed or experienced violence from the defendant firsthand and sustained lasting trauma as a result. They have witnesses to back this up. All right, for example, in the early morning hours of December 22nd, 2011, the defendant and a co-conspirator kidnapped an individual at gunpoint to facilitate breaking into and entering the residence of another. They call this person Individual 1 going forward. Multiple witnesses would testify at trial to the events surrounding the kidnapping and break-in, the latter of which is corroborated by police reports and other records. Man, they went back to something from years ago. Approximately 2 weeks later, the defendant's co-conspirators set fire to Individual 1's vehicle by slicing open the car's convertible top and dropping a Molotov cocktail. That's where they stick a rag into a bottle of alcohol, light one end, and when the glass explodes, it causes a firebomb. Inside the interior, police and fire department reports extensively document the arson and conclude that the fire was intentionally set. Multiple witnesses will also testify to the defendant bragging about his role in destroying Individual 1's car. More broadly, since at least 2008, allegations of the defendant's physical abuse of women and others have been publicly reported in the media, including in Hollywood blogs and on podcasts. Law enforcement reports corroborate that police responded to several instances of the defendant's violence, including assaults against victims and other individuals. More recently, there has been an outpouring of public allegations against the defendant, including claims of threats and physical and sexual violence, dating back as far as the 1990s. All right, they have a number 3 here, and it shows some cases that have been filed in the past. In short, the defendant's violent tendencies are widely known. However, at no point during the past few decades has the threat of public exposure or law enforcement intervention deterred the defendant from continuing his abuse. Number 3, firearms. All right, now we're going to talk about the different firearms they've obtained from his houses. Number 3, the defendant and members of the enterprise, including the defendant's security personnel, at times carried firearms. And the defendant himself carried and brandished firearms to intimidate and threaten others. Indeed, some victims were aware of the defendant's access to firearms. On one occasion, the defendant forced a female victim to carry a firearm on his behalf, and on another occasion, he pointed a firearm at a female victim. The defendant continues to have access to guns, including illegal firearms. In March 2024, during searches of the defendant's residences in Miami, Florida, and Los Angeles, California, law enforcement seized firearms and ammunition, including 3 AR-15s, each with defaced serial numbers. That's a big one there. Why, as a millionaire, why would you need a defaced serial number? A serial number on a gun that can't be tracked? Why do you need a ghost gun? All right, let's jump back in. As well as a large capacity drum magazine. As pictured below in close-up images, the serial number on one of the AR-15s is visibly bored through and obscured. See right here? You can make your image bigger. Look right there. Actually, maybe I might be able to. All right. That's what it means to be a defaced serial number. All right. Let's jump down here. We're here in this section. All right. 2 of the 3 defaced AR-15s were found in the defendant's Miami bedroom closet. stored, broken down in parts, along with magazines that were loaded with ammunition, as depicted below. One of the AR-15s had a 10-round magazine loaded with 10 rounds of large caliber .223 ammunition, while the second AR-15 had a 30-round magazine loaded with 19 rounds of .223 ammunition. All right, there's a picture of the guns there laid out. All right, a large capacity drum magazine loaded with 59 rounds of .223 ammunition was seized from the defendant's Los Angeles residence, as depicted below. In addition, 6 legally purchased guns with serial numbers well, we need that to happen. Boop, boop. All right. Where are we at? Some of which were stored in gun safes were recovered from the defendant's residences. Although these particular guns, both the legal and illegal firearms, were seized, their presence in the defendant's homes demonstrates that the defendant has access to and surrounds himself with both guns and ammunition. Likewise, even if the defendant were personally restrained by the court from obtaining new firearms himself, he could retain access to, or he could, yes, retain access to them through others. In some, the defendant's regular use of violence and threats of violence, as well as the coercion described above against the victims and others, fostered a culture of fear in which these individuals believed they were unable to reject the defendant's demands without subjecting themselves to physical violence or abuse. All right. B. Combs bribed witnesses and obstructed justice. All right, this one says, throughout the time period charged in the indictment, when the defendant faced the possibility that his violent and criminal conduct could become public, the defendant and other members and associates of the enterprise pressured witnesses and victims not to report what they saw or heard to law enforcement, or to otherwise conceal the criminal conduct. For example, and as noted above, in March 2016, the defendant was captured on video surveillance striking, kicking, and dragging a woman in a public area of a hotel in an apparent attempt to prevent her from leaving a freak-off. When a member of the hotel security staff intervened, the defendant attempted to offer the hotel security officer a stack of cash to ensure his silence. After the security guard refused the defendant's bribe, and after coordination between the defendant and his employees, the defendant's staff conducted or contacted other members of hotel security. At the same time, staff members were in close communication with the victim of the assault as well, all in an effort to cover up the defendant's assault and to prevent the incident from being publicly disclosed. Within days of the incident, the surveillance video disappeared from the hotel's server. Similarly, throughout the time period charged in the indictment, members and associates of the enterprise have reached out to multiple victims on behalf of the defendant to convince them not to report the defendant's abuse. Most recently, in late 2023, immediately following public allegations of certain of the defendant's crimes, including his physical and sexual abuse of women, the defendant and other members of the enterprise made repeated phone calls to victims and witnesses, during which they provided victims and witnesses with false narratives of events. In an apparent effort to conceal the defendant's crimes. On at least 2 occasions, the defendant recorded those calls on a co-conspirator's cell phone, thereby attempting to obscure his involvement with the obstruction. C. The government's investigation is ongoing. While the indictment against the defendant was unsealed today, the investigation into his and other co-conspirators' conduct is active and ongoing. As a result of that ongoing investigation, as well as the defendant's charged conduct outlined above, including obstruction of justice and witness tampering, the government is limited in its ability to fully set forth all known details of the defendant's criminal conduct, including details of certain witness testimony. To the extent that the court has additional questions about the charged offense conduct or any other information set forth herein, the government is prepared to proffer additional information on an ex parte basis. That means without the other side being present. All right, usually that's not allowed, okay? In certain circumstances, it can be allowed. Applicable law. Under Bail Reform Act 18 U.S.C. Section 3141, wherever you see ETSEQ, that means executor. That means in all that follows. So it means you go look here first, and then you look at all the law that comes after that. All right? Federal courts are empowered to order a defendant's detention pending trial upon a determination that the defendant is either a danger to the community or a risk of flight. All right, this is where you find that 3142C, or that's E. Yes. All right. A finding of risk of flight must be supported by a preponderance of the evidence. That means 51% of the evidence must show that this person is a risk of flight. A finding of dangerousness must be supported by clear and convincing evidence. So if you're going to call a person dangerous, you need even more evidence. Okay, when you're going to flight risk, you need less evidence. You need 51%. Going to call a person dangerous, and that's the reason why you don't want them to get bail. You have to have 75% or more. Obstruction of justice is another ground for pretrial detention by the courts. All right, courts in the Second Circuit have held that pretrial detention for obstruction of justice is appropriate as long as the government can establish a clear or by clear and convincing evidence that there exists a serious risk the defendant would threaten, injure, or intimidate a prospective witness or juror. The Bail Reform Act lists 4 factors to be considered in the detention analysis. Number 1, the nature and circumstance of the crimes charged, including whether the offense is a violation of Section 1591. Number 2, the weight of the evidence against the person. Number 3, the history and characteristics of the defendant, including the person's character, past conduct, ellipsis, and financial resources. And number 4, the nature and seriousness of the danger to the person, to the community, that would be posed by the person's release. All right. The concept of dangerousness encompasses not only the effect of the defendant's release on the safety of identifiable individuals, such as victims and witnesses, but also the danger that the defendant might engage in criminal activity to the detriment of the community. That's an interesting argument. A finding of dangerousness does not require that the defendant have a criminal history, particularly if the defendant has a history of domestic violence. All right. Evidentiary rules do not apply to detention hearings, and the government is entitled to present evidence by way of proffer, among other means. Where a judicial officer concludes after a hearing that no condition or combination of conditions will reasonably assure the appearance of the person as required and the safety of any other person and the community, such judicial officer shall order the detention of a person before trial. All right, that just means simply that if a person can't submit to some sort of conditions of their release, then they'll be held until a trial happens. Additionally, where, as here, the defendant is charged with sex trafficking, in other words, an offense under Chapter 77 of Title 18, it shall be presumed, subject to rebuttal, that no condition or combination of conditions will reasonably assure the appearance of the defendant as required and the safety of the community. Whew. All right, they have discussion. All right, this is when they're going to get more into the meat of what they're saying and give more reasons behind why they're saying it. If you see, much of legal writing is you tell someone what you're about to tell them about, you tell them the thing, and then you continually keep telling them about what you just told them about, if that makes sense. You explain what you're about to talk about. That's an overview. You talk about it. And then you continually keep going back and telling somebody what you just told them about. All right, discussion. For the reasons set forth below, the defendant poses a significant danger to the community, both in terms of physical violence and the obstructive conduct, as well as a risk of flight. This is especially true given the nature of the criminal conduct and the strong weight of the evidence. The defendant therefore cannot overcome the statutory presumption in favor of detention in this case. A. Dangerousness. The defendant is charged with serious and violent crimes. As charged in the indictment, the defendant has physically and sexually abused women and others for the best part of 2 decades. The sex trafficking charges based on the defendant's abusive conduct, count 2, from the indictment, that's what we're talking about, carries with it a presumptive detention. And they cite to the part of the law so the judge can take a look at it. Look at this. They're pointing the judge like, hey, look, judge, we want you to look at this part of the law. If you don't look at nothing else, please go back and look at this part. And now they're going to tell the judge some more. And detention is particularly supported by the facts of this case. Since at least 2008, the defendant has engaged in serious acts of violence, including forcing and coercing women to participate in sexual activity, including sex acts with commercial sex workers, by using physical force, financial pressure, emotional abuse, and narcotics. These acts, described in detail above, were referred to as freak-offs, among other names, and involved orchestrated sexual performances facilitated through drug use that sometimes lasted days at a time. All right? This is not all. As set forth in the indictment, the charges against the defendant capture significant additional violence, both spontaneous and premeditated. On numerous occasions, the defendant assaulted women, employees, and others when he became enraged by throwing objects at them, choking them, pushing them, kicking them, and slamming them against walls and on the ground. The defendant and other members and associates of the enterprise were also capable of premeditated violence, resorting to kidnapping and arson when the defendant's power and control were threatened. The defendant's violence, whether spontaneous or premeditated, had the effect of exerting his continued control over these individuals. The defendant also carried firearms to intimidate and threaten others. Multiple defaced semi-automatic rifles were recovered when law enforcement searched the defendant's residences in March 2024. It's crazy when you think about that search of his homes happened 6 months ago. That they let a whole 6 months go by before they finally arrested Sean Combs. Interesting, right? Including 2 defaced rifles that had been disassembled and hidden in the defendant's bedroom closet. In short, the conduct with which the defendant is charged shows a pattern of violence and abusive conduct, underscoring his dangerousness. This disposition to violence cannot be reasonably prevented through bail conditions. I mean, there's nothing that you can force him to do or have a condition that he do that will stop his violent tendencies. That's what they're saying. The violence alleged in this indictment or in the indictment was not isolated or aberrational. It was systemic and pervasive. The defendant abused women with whom he was in personal relationships, employees, witnesses to his crimes, and others. As described above, the defendant has sexually, physically, and emotionally abused long-term romantic partners for decades, including by forcing them to engage in freak-offs. This is crazy, right? Sometimes the evidence is just it sounds so bad. It's just so crazy. All right, let's jump back in. The defendant has abused countless others in his orbit, and in particular, women without regard for consequences. Indeed, the defendant's abuse of women long predates the conduct charged in the indictment. To date, at least 5 women have publicly accused the defendant of violent sexual assaults dating back to the 1990s. Moreover, the defendant's violence and abuse often occurred behind closed doors, including in his homes, hotels where he was staying, and other private settings. He has assaulted victims, employees, and others, and even brandished a firearm at a victim in his home or in his homes. The alleged sex trafficking similarly took place in a private setting, not easily monitored. Indeed, in addition to engaging in freak-offs at hotels, the defendant has at times organized freak-offs at his home or at homes of his female victims. This is precisely the kind of violence that even strict conditions such as home incarceration cannot prevent. In sum, the defendant's long history of violent conduct makes clear that even the most stringent bail conditions will not suffice to ensure the safety of the community. See, basically, you see what what the play is. The government has to paint the defendant as a person that's so bad they should not be placed on bond. The job of the defense attorney is to paint the situation where the defendant has already done so much and was not ever trying to run, so please grant us a bail. All right, let's jump back in. All right, the defendant is a serial abuser who repeatedly assaults and coerces women to achieve his own sexual gratification, and uses his vast wealth and position of power in the entertainment industry to conceal his illegal conduct and prevent victims of and witnesses to his abuse from coming forward. The defendant's long-standing pattern of abuse is probative evidence of the likelihood that he will continue to abuse. Indeed, nothing, not even the threat of public exposure or law enforcement intervention, has stopped his abuse. The defendant has continued to physically assault and threaten those around him, including his romantic partners, his employees, and others who happened to be present when he succumbed to fits of rage. No bail conditions can address the defendant's tendency to become violent when angry or emotional. Anyone in his presence is at risk of abuse or assault, and the defendant's physical assaults are serious, resulting at times in serious injury requiring medical intervention and long periods of recovery. Therefore, the nature and seriousness of the danger to any person is both real and specific. All right, obstruction. All right, we're going to pause there and I'll come back. All right, let's jump back in. We're on obstruction. All right, as part of the charge, racketeering conspiracy, the defendant engaged in obstruction of justice, including bribery and witness tampering. Given the defendant's history of engaging in obstructive conduct to conceal his criminal activity, both personally and through intermediaries, there is every reason to believe that the defendant will continue to engage in such obstruction if released. As detailed in the indictment, following a freak-off in March 2016, the defendant attempted to bribe hotel security staff to prevent hotel security from publicly disclosing and or reporting to law enforcement his vicious attack on a woman attempting to leave a freak-off. The defendant's efforts to disclaim responsibility for that attack continued until earlier this year. A civil lawsuit was filed on or about November 16, 2023, alleging years of sexual, emotional, verbal, and physical abuse by the defendant, including allegations describing the March 2016 indictment, or incident, Following the filing of the lawsuit, the defendant stated in no uncertain terms, "Let me be absolutely clear. I did not do any of the awful things being alleged." Through counsel, the defendant vehemently denied these offensive and outrageous allegations, describing the complaint as riddled with baseless and outrageous lies. It was not until the video surveillance footage of the defendant's attack was leaked to the media months later that the defendant was forced to admit that he had, in fact, perpetrated the disgusting attack. Clearly, the defendant is willing to deflect, minimize, and lie to induce others to do so on his behalf, to avoid taking responsibility for his own actions. So do you see where they're going with this? They're asking the judge, and they're painting a picture. They're basically saying that no matter what you do, the judge, no matter how you say it, Mr. Combs is going to do whatever he can to minimize the situation and try to fix it. He'll spend money, he'll intimidate people, he might even do worse to people. And for that reason, Judge, you should make him remain incarcerated until he goes to trial. Let's jump back in. More recently, the defendant has directly and through intermediaries engaged in obstructive conduct related to the matters under investigation in this case, specifically following the November 2023 lawsuit. The defendant and intermediaries acting on his behalf reached out to potential victims and witnesses to the alleged conduct, including individuals he did not speak to regularly and had not spoken to in years, to attempt to feed those victims and witnesses false narratives about the defendant's criminal conduct. With respect to at least two of these individuals, the defendant's co-conspirators assisted in efforts to protect the defendant. For example, on or about November 19, 2023, just 3 days after the filing of the lawsuit described above, the defendant made multiple calls to another victim of his sexual abuse and recorded certain of those calls using the cell phone of a co-conspirator. During the calls, the defendant repeatedly asked for the victim's support and friendship and attempted to convince the victim that she had willingly engaged in acts constituting sexual abuse. The defendant also assured the victim that if she needed the defendant to, she ain't got, I guess she doesn't have to worry about anything else. A thinly veiled attempt to coerce the victim into adopting and supporting the defendant's false version of the events to protect the defendant. Even more concerning, since learning about the criminal investigation, including following the execution of the search warrants at his residences, Combs contacted other witnesses on multiple occasions, including other witnesses who had received grand jury subpoenas. The defendant's recent conduct is similar to that in United States v. LaFontaine, all right, in which the Second Circuit affirmed the district court's revocation of pretrial release after the defendant in that case engaged in witness tampering. All right, so they're given a case that's dealing specifically with witness tampering. Specifically, the defendant, who was charged with multiple counts of fraud in connection with providing false claims to medical insurers, called a witness to remind the witness that the particular patient had received surgeries that the patient had not had, in fact, received. All right, so somebody called up some witnesses trying to let them know, hey, look, you were in on this, so don't, if I go down, you go down, basically. That's what some veiled threats. The Second Circuit affirmed the district court's finding that there was no condition or combination of conditions that will assure the safety of the community given the defendant's witness tampering. So they took it very serious. Witness tampering was seen as very serious a thing, and someone was denied bail. All right. In rejecting the defendant's arguments and that district court's findings of dangerousness was not justifiable, the second court noted that the defendant had fed the witness false testimony with the expectation that the witness would adopt it, and that even stringent electronic monitoring conditions could be circumvented. Here, the defendant's conduct goes beyond what the LaFontaine court faced or court found sufficient to revoke bail. Even before being charged with a crime, the defendant has taken numerous proactive steps to tamper with potential witnesses' testimony against him. The government is aware through electronic evidence, toll records, conversations with witnesses, and other evidence that the defendant has contacted witnesses, including subpoenaed witnesses, prior to the dates on which the witnesses were required to appear before the grand jury. They're putting out the information. They're sprinkling it out there. They're alleging that he tried to tamper with witnesses before the grand jury was even done, but they found out about it. In addition, the defendant has recorded calls with at least one victim and provided either directly or through intermediaries false narratives on the events that transpired so that those witnesses would adopt the false testimony. Moreover, the defendant's obstructive conduct is made even more alarming by the manner in which he carried it out to evade detection, in some instances by having intermediaries make calls on his behalf and recording certain calls on another individual's device. These deliberate actions show that the defendant was aware that he was doing, or what he was doing was obstructive, and that his aim was to evade detection. Even the most stringent conditions, including monitoring of a court-authorized device, would fail to ensure the defendant would not engage in this kind of obstruction from his home, including by acting through intermediaries and using others' devices. Given the defendant's history of obstruction, as well as violent nature of the charges against the defendant cannot overcome the presumption that no condition or combination of conditions can assure the safety of the community. All right, so that was a lot, guys. All right, and we still haven't got to the last one, which is the flight risk. All right, it's about 4 more pages here. Remember, you can always skip through. We have chapters outlined, so you can skip to the portions that seem interesting to you. Let's deal with the flight risk. Let's see where we're at. All right, let's see. Put my phone in. All right, C, flight or risk of flight. nor can the defendant overcome the presumption that he is a risk of flight. The crimes that the defendant is charged with carry significant penalties, including a mandatory minimum sentence of 15 years imprisonment and a statutory maximum sentence of life imprisonment. So they're saying on one of these charges that he's looking at has a minimum of 15 years. All right, the possibility of a substantial sentence is a significant factor in assessing the risk of flight. Here, the defendant is facing at least 15 years imprisonment if he is convicted. This fact alone will provide a compelling incentive for anyone to flee from prosecution, but the incentive to flee is especially strong for this defendant who, at age 54, faces the very real prospect of spending a substantial portion of the rest of his life in prison. As detailed below, the evidence in this case is incredibly powerful, as the facts set forth in the indictment and herein make plain. Dozens of victims and witnesses have provided detailed, credible, and corroborated information against the defendant. These individuals include many who personally experienced and witnessed violence and other crimes at the hand of the defendant. Moreover, their accounts are well corroborated by significant extrinsic evidence, by significant outside evidence, including financial and billing records, travel records, electronic data, and communication, including extensive communications by and with the defendant himself. For example, victim testimony regarding freak-offs is at times corroborated by other witness testimony, communications with the defendant and commercial sex workers, travel records, hotel records, videos of the freak-offs, and records for reflecting or indicating payment. Similarly, a victim's physical abuse may be corroborated by, among other things, videos of the abuse, photos of injuries, reports made to law enforcement, communications with the defendant and others, and testimony from other witnesses who saw or heard about the abuse. The vast and varied sources of evidence described in detail below will be compelling evidence of guilt at any trial in this case. Thus, the serious risk of conviction provides further incentive for the defendant to flee prosecution. All right, that's a compelling story. That's a compelling argument. And they basically just pointed out that Sean Combs is 54 years old. 15 years to 54 makes him 69 when he gets out, with the first opportunity of getting out of prison. The first opportunity. Could be way longer. But you're talking about doing 9% of the time, 15 years. That's a lot. Let's jump back in. Moreover, in this case, risk of flight is augmented by the nature of the evidence against the defendant. The evidence against the defendant, which would be made public at trial, includes substantial evidence that is highly sensitive and has the potential to significantly and negatively impact the defendant's reputation. For example, dozens of video recordings created by the defendant of freak-offs with victims. For decades, the defendant has spent significant time and resources in ensuring that his criminal conduct avoids public scrutiny. That means it avoids the public eye. Given the potential penalties here, both incarceration and reputational harm, the defendant has every incentive to flee to avoid prosecution and a public trial. The defendant's incentive to flee, outlined above, coupled with the defendant's seemingly limitless resources, meaning that he has access to a bunch of money, unlimited money. I don't know if that's true or not, but at least to an average person, he has access to a lot more money than most people have, you would think. All right. Defendant's seemingly limitless resources create significant risk of non-appearance. The defendant's net worth is publicly estimated at being close to $1 billion. $1 billion with a B. Indeed, the investigation of his case has revealed that the defendant has access to vast funds and resources, including deep reserves of cash, which would facilitate his evasion of prosecution. At least as of December 2023, the defendant had access to dozens of bank accounts, some personal and many under corporate entities, which contain millions of dollars. Additionally, as of December 2023, the defendant had over $1 million in personal cash on hand. The defendant has traveled internationally several times per year since at least 2006, and since approximately 2019 has owned a personal plane on which he has traveled internationally. The defendant maintains two primary residences in Los Angeles and Miami. In addition to his private plane, the defendant owns multiple vehicles in multiple locations. He has a personal staff, including assistants, security, chefs, trainers, and others, who perform tasks at his command, including transporting him, delivering him currency, securing narcotics for him, and other tasks. And he is extraordinarily well connected both within and outside the entertainment industry. In short, if the defendant wanted to flee, he has the money, the manpower, and tools to do so quickly and without detection. The defendant's lack of access to his passport or private jet would not negate the fact that the defendant could buy his way out of facing justice. They're attacking on all fronts. All right. As discussed below, the defendant's legal team has attempted to mitigate the substantial risk of flight by taking steps such as taking his family's passports, attempting to sell his plane, and reporting his whereabouts to the government. These steps have been taken with the precise goal of crafting an argument for bail before the court. While the defendant may have made the calculated decision in consultation with his attorneys not to flee before any charges were filed, that calculus inevitably changes today when an indictment charging the defendant with extremely serious offenses carrying enormous potential penalties was unsealed. He is now, for the first time in his life, facing mandatory minimum terms of imprisonment of 15 years and a maximum term of life imprisonment, in which the government is prepared to prove the charges against him by, among other things, the testimony of dozens of witnesses. 1 dozen means 12. When they say dozens, they mean at least you got 2. So 24 or more witnesses and victims to his serial abuse, and evidence from dozens of his own electronic devices and those of his co-conspirators. Given the serious nature of the charges, the strength of the evidence, and the defendant's access to vast amounts of resources, his risk of flight is more pronounced today than it has ever been. Okay, let's jump back in. We have D, the weight of the evidence. In considering the danger and risk of flight presented by the defendant, the court is also required to consider the weight of the evidence against the defendant. The defendant faces a strong and powerful case here, only magnifying the danger he could present to others, especially victims and witnesses ready to testify against him, and the risk he flees. The evidence in this case consists of a vast amount of victim and witness testimony, electronic evidence, physical evidence, and subpoenas, subpoena returns, and other voluntary productions, among other things. As to witnesses, to date, the government has conducted interviews with over 50 victims and witnesses, many of whom saw or experienced the defendant's abuse. Many of these witnesses corroborate one another, and their accounts are similarly consistent with the other types of evidence discussed below. The government only expects that number to continue to grow, given that the investigation, which is now public, is ongoing. The electronic evidence is similarly vast. The government has sought and obtained numerous search warrants for such evidence, in addition to obtaining evidence voluntarily from certain victims and witnesses. Setting aside devices seized in connection with the defendant's arrest, the government has obtained over 90 cell phones, laptops, and cloud storage accounts, as well as over 30 other electronic and storage devices, such as hard drives, thumb drives, cameras, and other surveillance systems. The electronic data comes from the defendant himself, as well as co-conspirators, victims, and witnesses, and chronicles much of the defendant's criminal activity as it occurs. The evidence is also consists of physical evidence, which was seized pursuant to a search warrant executed at the defendant's residences in Los Angeles and Miami, as well as on his person and the persons of certain co-conspirators. In addition to the firearms and electronics discussed above, the physical evidence also includes other evidence of freak-offs, including over 1,000 bottles of baby oil and personal lubricant. Finally, the evidence includes records obtained pursuant to over 300 grand jury subpoenas and other voluntary productions. These materials come from over 100 entities and individuals, including communication providers, tech companies, social media companies, banks, and other financial institutions, airlines, hotels, car services, and other travel-related companies, escort services, and even the defendant's companies and wealth management firm. Together, this evidence, as well as other evidence gathered, powerfully demonstrates the defendant's guilt and counsels in favor of detention. All right, the defendant's bail package is insufficient. All right, now they're going to get into and talk about what the defense has already offered as their proposed bail package. E, the defendant's proposed bail package is insufficient. For all the reasons set forth herein, there is no bail package that can reasonably assure the safety of others in this case. Where the defendant has engaged in decades-long patterns of violence against women and others, and has used his wealth and power to ensure the criminal conduct goes unpunished through manipulative and obstructive conduct. In particular, the bail package proposed by defense counsel is insufficient because it fails to adequately protect others from the defendant's violence, impose measures to prevent and detect obstruction, or prevent the defendant from accessing his vast resources, including millions of dollars in cash, to evade prosecution, or dissipating those assets to avoid financial penalties for his crimes. Defense counsel has proposed certain bail conditions, including home detention with electronic monitoring and a $50 million bond secured by the defendant's Miami property. These conditions are plainly insufficient to address the legitimate concerns set out above. In particular, given the defendant's history of engaging in obstructive conduct, the court must reject the insufficient conditions proposed by defense counsel, which do nothing to prevent and detect such conduct. For example, in United States v. Farinetti, a case in which the defendant was charged with witness tampering and where obstruction remained an ongoing concern, the Second Circuit, that's the same circuit that this New York case is in, reversed the district court's release of defendant on bail conditions because a $1 million bond, which was to be secured by properties owned by the defendant and members of his family, only deterred flight, but not danger. So the argument they put forth here is saying that sometimes being able to make the bond only ensures that a person will not try to run. It doesn't ensure that they won't try to tamper with witnesses. More specifically, the Second Circuit found that the district court's bail condition intended to address witness tampering which was a general prohibition that the defendant was not to commit a crime or intimidate a witness, does not at all impede his ability to do so, and requires no more of him than that which the law already demands from the defendant and every other citizen. All right. Notably, the defendant's previously proposed conditions do not include provisions related to his access to electronic devices, which, as outlined above, the defendant uses to engage in obstructive conduct. Nor do the proposed conditions include information related to or restrictions on access to the defendant's vast resources, including multiple personal bank accounts in the name of the defendant's business, and deep cash reserves, which could facilitate the defendant's flight. Similarly, the proposed conditions fail to protect against dissipation of assets, which may be subject to forfeiture or penalties on the charges in the indictment. Finally, the proposed conditions do not include conditions which would limit the defendant's potential to engage in violence or abuse, such as drug testing and treatment and surrender of all firearms. Conclusion: as set forth, the defendant poses an ongoing and significant danger to the community, has repeatedly engaged in obstructive conduct, and presents a serious risk of flight. The government specifically submits that the defendant cannot meet his burden of overcoming the appearance and compliance of the defendant, cannot meet his burden of overcoming the statutory presumption in favor of detention. There are no conditions of bail that will assure the appearance and compliance of the defendant or the safety of others. Accordingly, any application for bail should be denied. This is signed by Damian Williams, the United States Attorney for the Southern District of New York. All right, so intricate document. It goes over everything that was dealt with in the indictment, and this was basically a letter to the judge saying, "Judge, when we get ready to come in front of you later on today," and this was yesterday, so when we get ready to come in front of you later today, asking that you not grant Sean Combs bail, this is why we're saying that. And they just sort of lay it out. And they say they have evidence to back up everything. And if the judge wants to see that, they can proffer it, which means they can just produce it and let the judge see it without any objection. All right? Let's see if there's anything in particular that we want to pull out and talk about a little bit more before I let you go, because this one is quite long since we read through everything. But a key thing to remember, okay? Now, if you yourself or anybody you know is ever dealing with a federal indictment, you need to hire an attorney, okay? You cannot go through this process alone. And while you may have a right to go through this process alone, it's never recommended. One thing is for certain, dealing with the Sean Combs case, he's going to be incarcerated. He's going to be in jail until they have his jury trial right now. Now, there may be another motion that comes out requesting that he be granted bail for some reason or another. But right now, he has not overcome the presumption that calls for detention based on the nature of the charges that have been levied against him. All right? I haven't been able to find the order denying bail, but I'm sure that will come out in the next few days or so. All right? If you have any comments, put them below. Go and view some of the other videos. Give a like to this video. And I will see you in our next video. This is going to be night school session number 4. All right, with that, this is Professor Ross. This was Advocacy Alchemy, and you all have a good evening.